You are welcome to yet another episode of HN What's Your Say? The #1 listening show, where we discuss real issues with real people like you. We are still featuring R. Kelly. Real name Robert Sylvester Kelly. Also known as the R&B King. In the world of American justice, there are cases that not only capture public attention, but also expose the deeper cracks running through the system itself. The Chicago appeal hearing for Robert Kelly, known to millions as R. Kelly, was one of those moments. And within that hearing, a revelation emerged that was as shocking as it was disturbing. The government's position, as revealed in the audio of the Chicago appeal proceedings we are going to play you, made it clear just how District Federal Judge Harry Leinenweber drew his own conclusions about obstruction of justice. Despite the fact that the jury, the body constitutionally empowered to weigh evidence and deliver a verdict, had not reached such a conclusion, Judge Leinenweber placed his own inference above theirs. This was more than a slip of the tongue, more than a moment of judicial overreach. It was a window into a system that increasingly no longer respects one of its most sacred principles, the standard of proof beyond reasonable doubt. To understand the weight of this, we must pause and remember what beyond reasonable doubt really means. It is not just a legal technicality. It is the bedrock of fairness in criminal trials. It is the shield that protects citizens from the unchecked power of the state. The government must prove its case, fully and convincingly, leaving no reasonable room for uncertainty. It is not the duty of the accused to prove innocence. It is rather the duty of the state to prove guilt. Yet here, in this Chicago appeal hearing, we heard something else. We heard a judge substitute his own belief for the absence of conclusive evidence. We heard a judge dismiss the fact that the jury, after listening to testimony, after weighing the government's claims, after considering the evidence, had not decided obstruction of justice was proven. In place of the jury's silence, Judge Leinenweber spoke his own verdict. And this is where the danger begins.
So just to pin this down with clarity, your position is that Judge Leinenweber made the findings necessary to consider the obstructive conduct?
Yes, Your Honor.
Because when a judge acts as though he has conducted a parallel investigation, reaching conclusions beyond what the trial itself established, justice is no longer blind. It is prejudiced. It is predetermined. And it is dangerous. This is not just about R. Kelly. This is about the principle that no man or woman should be condemned on the basis of assumption. This is about the idea that no judge should replace the role of the jury with his own personal conviction. For if the presumption of innocence can be so easily brushed aside, then how many people right now are sitting in prison cells serving long punishing sentences because of presumptive and careless decisions just like this one? The Chicago appeal hearing revealed more than prejudice. It revealed an attitude from the trial court which was equally condoned by the appeals court. Judge Leinenweber's insistence on obstruction, even against the jury's opinion, showed us what happens when a courtroom becomes a place of personal inference rather than legal proof. It showed us a judiciary willing to sidestep the core protections that the Constitution demands. And the prejudice was real. Think about what that means. Prejudice is not always loud. It does not always shout. Sometimes it whispers in such subtle inferences, in conclusions drawn without basis, in a judge's quiet certainty that he knows better than the jury. But whether loud or quiet, prejudice erodes justice just the same. And so in R. Kelly's defense, we must say this plainly: what took place in that appeal hearing was wrong. It undermined not just his rights but the rights of anyone who ever sets foot in a courtroom. This should in fact alarm every citizen who believes in fairness, every person who still hopes that American justice lives up to its promise. Let us imagine this scenario outside of Kelly's case. A man is tried for a crime. The jury does not convict him of obstruction. Yet the judge decides that based on his own perception that obstruction occurred. That man is then sentenced, punished and labeled for a crime that the jury did not find beyond reasonable doubt. Would we call that justice? Or would we call it tyranny dressed in robes? The sad reality is that R. Kelly's case is a mirror reflecting not only his struggle, but also the silent suffering of countless others who may be behind bars because judges, prosecutors, and courts chose presumption over proof. The erosion of beyond reasonable doubt is not small. It is not harmless. It is the unraveling of the very promise that the justice system makes to its people. And once unraveled, it leaves behind a courtroom where anything can be justified. Where belief replaces fact, where bias replaces evidence, and where prejudice replaces fairness. When Judge Leinenweber decided to act as though he had conducted his own private investigation, he crossed a line. He set aside the neutral role of the bench. He became both judge and investigator, weighing not what the trial had proven, but what he himself had concluded. And in doing so, he compromised the integrity of the entire process. That is why this moment matters. That is why the audio from the appeal hearing is not just a footnote but a revelation. It shows us how fragile justice can be when men of power forget their boundaries. We must not underestimate the impact of this. For if one man's case can be handled in this way, then all men are at risk. If Robert Kelly, a world-renowned artist with resources, lawyers and public attention can face this level of prejudice, then what chance does the average faceless defendant have? The Chicago appeal hearing stripped bare the illusion. It told us that in some courtrooms, the presumption of innocence is no longer honored. It told us that even when a jury refuses to convict on a specific charge, a judge may still insist otherwise. It told us that the sacred promise of proof beyond reasonable doubt is being replaced by something darker. Proof by assumption, proof by prejudice, and proof by personal conviction. And this should trouble us deeply. Because once the system abandons its own rules, it is no longer a system of justice. It is a system of control. In R. Kelly's defense, we return to the core truth: he, like any man, deserves a trial rooted in fairness, in evidence, and in proof beyond reasonable doubt. He, like any man, deserves protection from judicial overreach. And he, like any man, should not be condemned because a judge decided to act like a parallel investigator. This is why we must speak. This is why the revelation of Judge Leinenweber's inference matters. It is not simply about whether one believes Kelly is guilty or innocent. It is about whether the standard of proof beyond reasonable doubt still means anything in America today. For if it does not, then the door is open for countless wrongful convictions. The door is open for prejudice to become practice. And the door is open for liberty to be lost in silence. The prejudice was real. The danger is clear. And the time to question this system is now. That is all we had for you today on HN What's Your Say? To keep updated whenever we post a new video, subscribe to this channel now. Also remember to hit the bell icon and enable notifications. And feel free to share your opinions with us in the comment section below, and let us know if you would like us to publish your views in our next release. We value all our subscribers' opinions.